There we go. Well, welcome everybody. We're very pleased on behalf of the ILESC committee to present this panel on pathways to careers in international law with my co-chair Carole Silver. I'm Ryan Reetz, and we're going to moderate, but we're very pleased to have a distinguished panel of lawyers here who are going to talk about their pathways to careers in international law. Um, we could spend our hour telling you how great they are, but that's probably not the best use of anyone's time. So I'll just introduce people very quickly, and we can sort of kick it off. Um, Alphabetically, first we have Chris Campbell, who is a senior litigation counsel with Baker Hughes in Florence, Italy, and elsewhere. Then we have Dan Gonzalez, who's a partner with Hogan Lovells in Miami. Uh, then we have Eric Ives, who is a senior counsel for Europe with the Commercial Law Development Program at the U.S. Department of Commerce. We have Yasmin Lalou, who's a partner at Chaffetz Lindsay in New York. And finally, Takayuki Ono, who's a partner with Sidley Austin in Chicago. So as you can see, we're all around the map here. I guess probably the best thing to do is to start out with what you all are doing. Each of you has a practice involving international law in some form, but you're all doing something a little bit different and in a different place. And perhaps each of you can tell us a little bit about where you're working and your current practice. And maybe we could start with Chris.
Sure, glad to do it. And as you rightly mentioned, Ryan, as you can tell from my heavy Italian accent, I'm based in Florence, but I'm actually from the great state of South Carolina, in the U.S. I'm at Baker Hughes. I'm an in-house litigator. So Baker Hughes, despite sounding like a law firm, is not. It's an energy company. We do oil and gas and energy projects all over the globe. And when I say I'm an in-house litigator, that means when we are being sued or taken to arbitration or negotiating a deal somewhere in the world, I represent the company in those disputes. And oftentimes that means appearing before international arbitration tribunals and mediation, international mediator context and resolving disputes. So that's fundamentally what I do day in and day out as an in-house litigator.
Fantastic. Dan, as an outhouse lawyer, tell us about yourself.
Yeah. Outhouse is the right word, I guess, right? That's how I often feel we are at. But so I'm in not as nice as Florence, Italy, but I am in sunny Miami, Florida, and where it's right now warm again in the mid 70s. I've practiced though pretty much anywhere other than Miami. Our practice out of Miami is very international in the sense that our clients and our projects are kind of all around the world. A lot in the energy sector. There's a lot of feedback on another line. I can't. Is anybody hearing that?
Yes,
Yeah.
to our folks on the line, if you're not speaking and you're not a panelist, if you wouldn't mind just muting yourself, we will have time for questions later.
Okay, thank you. So nowadays, as you're asking about currently, I think our practice is pretty much divided between commercial, international arbitration disputes, as well as investment treaty disputes. And in that regard, we're also equally split between representing governments in certain investment disputes versus also representing the individual investor parties in those disputes. As far as industry sectors, I mentioned we do a lot in the energy, but really the way I would describe it is everything dealing with infrastructure development around the world. So whether it's energy, technology, telecom, other forms of infrastructure developments that touches on any part of the world, that tends to be the kind of disputes we have. That also touches on M&A deals gone bad and those sort of issues. But normally it's something where something went really bad, really wrong, and we get a call to help somebody.
Sounds good. Thank you. Eric, you've escaped big law. What are you up to? And you're on mute. Yeah.
Hey, yeah, thanks. I hope everyone can see and hear me all right. Let me know if that's not the case. Thanks so much to Ryan and Carole for having me and for the ILS section for inviting me along to share about what we're up to over here. My name is Eric Ives. I'm Senior Counsel for Europe at the Commercial Law Development Program at the United States Department of Commerce. I'll say it's a distinctly different type of lawyering, whereas I imagine my colleagues will talk about isolated disputes representing a discrete client. Our client is the US government, and our role is really theorizing a change that we see in another jurisdiction that would encourage foreign direct investment there, ideally for American firms, to sort of improve the investment climate. or get rid of a barrier to trade. Obviously, it's been a very interesting year with the political tumult, but I like to think that our mandate is sort of politics agnostic because we are on the sort of trade promotion and national security promotion lines of effort. I'll maybe give a little overview geographically of our work and then some subject areas. I'm directly engaged in our work in Ukraine on procurement and P3 reform. They have a new law, glad to say it. And ideally, we'll be able to get some American firms in some of those P3 projects. But there are some more basic issues of procurement law that are longstanding carryovers from the USSR and the transition away from a communist economy. That sort of same set of issues is at play in Southern Europe and the Balkans and in sort of some of the Mediterranean states that, while they may be EU members, still have some issues in their economy that preclude foreign investment. I'll say CLDP is divided into regional teams as well as subject matter specific teams. So I'm the senior counsel for Europe, but we're also engaged in 4 other geographic areas, LATAM, APAC, and MENA and Africa, as well as on 2 specific lines of effort that are high priorities, one might say. That's cyber and telecoms, and then energy and critical minerals. And I will also use this platform for a shameless plug to say that many of our teams are hiring. So if anyone is interested in a career in international law, now may be the perfect opportunity. And I'll pause there.
Eric, I think you're about to get about 83 resumes by email.
I'll drop my email in the chat.
Sounds good. Yasmin, could you tell us about yourself, please?
Sure. Hello, everyone, like Eric, thank you very much for including me in this session. I also enjoy a lot hearing from Dan, Eric, and Chris about what they've been up to. I am a partner at a boutique firm in New York. We only do disputes, and my activity is essentially as counsel in international arbitration, like Dan, commercial arbitration, investor state. But we also have sort of developed another practice, which is enforcement work. We're here to enforce foreign awards and foreign judgments in the U.S. As you know, New York is a financial hub, and creditors are generally hopeful that they can find something here. If not the assets, at least the information on where the assets are, either in the U.S. or elsewhere. We focused on very much the same sort of industries as Dan: infrastructure, energy, construction. Our areas of focus have historically been Latin America, where there's a lot of work on investor state side, and as well as infrastructure projects, energy. We were one of the first boutiques in the US to open in the international arbitration arena, and it's been a very interesting trajectory to see how clients have perceived us and how we've been working with other firms. We all came from Clifford Chance when we started the firm, and so we were able to develop our own footprint, our own network, without being able to rely on having to rely on a Clifford Chance network. And it has positioned us in an interesting way, is that we co-counsel a lot. And we represent clients who need New York law advice. And we will do that part while the co-counsel abroad will handle the facts, etc. But there's also a growing need for sort of someone to step in and do the advocacy work. It sounds trite to say that international arbitration has adopted a lot of the US style advocacy style, that English is the dominant language, and there are some skills that are better prepared here in the US than elsewhere, especially when we talk about cross-examinations and the like. So, and we have been frequently now called to step in disputes that have no connection whatsoever with the US or New York, and just be the mouthpiece. And I will just sort of conclude that we are only in New York, but all our international arbitration partners have started their career outside the US and are qualified outside the US. And as a result, we we also have maintained very strong connections with our original jurisdictions or areas. And as a result, we pretty much involved in disputes all over the world.
Fantastic. And last but not least, Tak, could you tell us about yourself, please?
Sure. Hi, everyone. My name is Tak. I am a partner at Sidley Austin. I'm primarily based in Chicago, but I also spend some time in our Tokyo office. I practice white-collar defense and investigations. I also do high-stakes litigation that tend to be cross-border. I represent global companies and their affiliates throughout the world. I do a lot of work for Japanese companies, hence my Tokyo presence, which has been my interest since day one, which I can talk about later. But a lot of my practice deals with representing Japanese companies as well as their U.S. subsidiaries in U.S. enforcement and litigation actions. Aside from my Japanese practice, I do have clients who are based in the U.S. and in other parts of the world, and I've done investigations not only in Japan and the United States, but in Southeast Asia as well, like Philippines and Indonesia, India too. My practice spans a wide range of industries. I don't really have one industry, so I have matters that range from financial institution matters, healthcare, automotive, and other highly regulated industries. So that's a little bit about me, and I know that we want to move on to some other questions. So
thank you so much. So I wonder if each of you might say a little bit about when you first decided to pursue an international law practice and how you started out. And then third, in that context, did you consider any alternative career paths? And maybe we should start with Tak and go backwards.
Sure. I first decided that this is what I wanted to do when I was a junior in college, when I didn't even quite, it was actually the same time that I decided that I wanted to go to law school. I had interned at a law firm in Japan for just like a week, where I saw a bunch of US qualified Japanese speaking lawyers hard at work on their various cross-border matters. And I thought, oh, this is something that I would love to do, in part because I speak the language, and also because I wasn't sure what I wanted to do. So that's when my first interest in this practice occurred, but it's been a pretty long path since then, in that I went through law school and I did OCI and other interview processes where I found out that perhaps my language skill is not as sought after as I previously thought. Firms really not expressing that much interest in what I was trying to do, and I changed course a few times, at least with respect to framing of what I wanted to do, and ultimately it took a decent amount of time before I landed where I am now, where I do get to do the thing that I set out wanting to do as a junior in college.
Great. Yasmin?
Hello again. So me, it's sort of the result of a combination of the global trends when I was young and a student and luck. In the late 90s, which is when I went to law school, this is a few years after the world was shrinking. This is a few years after the Berlin Wall fell. It was the end of the Cold War. It was the so-called end of history of Fukuyama. And that was the beginning of the world as we know it now, and that may also be disappearing. This was the beginning of starting to meet people from the rest of the world, Asia, Eastern Europe, Latin America, depending on where you were. Around that time, my high school started their first dual degree program, dual language program, English and French, which was kind of revolutionary because if you were at the World Cup in France in 1998, you would know that the French are not very good with languages. So there was that, and then when I went to law school, it was one of the first experiments of dual degree common law, civil law experiments. So that was in Nanterre, and then came La Sorbonne, etc. And so this is how it came. And so from that perspective, it was sort of an obvious path for me once you chose those dual degree tracks, and those dual degree tracks were interesting because they had an international aspect, and it was you got to meet people from other schools because they came to our school to have that opportunity. So it was also a way to diversify. Then around that time, we saw a big explosion, big progress of the integration of EU law into national systems. And that as a matter of legal and intellectual framework that was fascinating. And that also sort of framed our legal culture and our legal minds towards an international analysis and attractiveness. And then the first firm I went to, they did international. It was a small firm in Paris, and they did some international work because most of their clients were Italian. But I got extremely lucky because I had never heard of the word international arbitration at the time. I didn't even know what it was. But when I started my work there, my boss got his first ICC arbitration, and then he got the bug, and he wouldn't want to hear about anything else. It was Alexis Moore. He turned out to be the president of the ICC court. But at the time I joined him, neither he nor I knew much about ICC arbitration. As you can guess, he's a fast learner. So this is very much how my path landed me where I am.
Oh, thank you. Eric?
Hey, thanks so much. I guess I've been interested in international trade law pretty much since the time I went to college, I guess. I guess I'd call myself maybe a child of multilateralism, if that makes sense. And I think I mean that to say that I sort of grew up in parallel with what I think actually Yasmin just alluded to, the sort of great flattening of the international order. Some may argue that has turned, but that was sort of how I first caught the bug. I've been doing international trade law. I mean, I remember in college, I researched the flow of military drones under different international conventions from, the US and Israel around the world. You could literally map how it was going and how it sort of tracked the politics of the day. Literally the date of the sale versus their developing relationships with other countries. And I'll just say that gasoline was poured on that fire when I worked at the State Department. And this just happened to be the summer when the United States government was negotiating and trying to sell, I'm going to maybe date myself, TTIP, the Transatlantic Trade and Investment Partnership, which was, I mean, at the time, it was a big push to sort of unifying the United States and the European Union. And it would have, I mean, in fairness, it would have provided trade rules for about 40% of global trade flows. And as you can imagine, there was a lot of pushback for a lot of different reasons. And I just remember being fascinated by the intersection of international trade rules with the politics, and then actually the exercise of approaching foreign counterparts. I mean, at that time, it was civil society, as well as the legal community in Germany, and trying to make the American case for consolidated rules under TTIP. And, I think the expression of views there, ultimately TTIP sort of got thrown out, maybe with the bathwater situation, for someone else to decide, not me. But I think that kernel just really sort of formed my views and my interest in international trade law. And in some ways led me to this role. I attended law school, similar to Yasmin, actually, not being super familiar about international arbitration or investment arbitration. But I attended Columbia Law School, and their program on international trade law and investment arbitration was so robust. And to me, it just seemed like an incarnation of the exact things that we had been duking it out with our European counterparts. And to be fair, investment arbitration was a big sticking point for TTIP. It was lauded as a boogeyman, sort of these shadowy tribunals that'll decide your health and regulatory standards. Query whether that has actually been borne out in practice. But it definitely inspired my interest to keep on with it in law school, and ultimately to join a firm and do some international commercial and investor state arbitration, to really sort of get a practical sense on how international trade flows work. Unfortunately, you're usually engaged when the investment's gone wrong in some spectacular way. But I'm happy to say that I'm now sort of on the front end, sort of facilitating, hopefully, successful deals as opposed to the ones that fall to disputes. Well, I'll pause there.
Great. Thank you so much. And Dan. Oops, you're muted. It's okay.
Sorry about that. So my story is not nearly as strategic as Eric and much closer to sort of dumb luck like Yasmin referred to. So my story actually begins, but has an international beginning and ending. So my story begins with my Cuban immigrant parents, who in our family, there were no lawyers. But my mother had lost everything during the Castro Revolution. And as a child, I was told, you're going to be a lawyer. I didn't know why, but it was somehow a plan that somehow in my future I would go back and reclaim all of her lands that she lost and so forth. Well, we all kind of know how that's turned out, although stay tuned. Maybe there's a new chapter to that one just yet. But there were no lawyers in my family, so I first went to undergraduate accounting, got an accounting degree, just making sure I hedged my bets because I'm not sure how this whole law thing was going to work out, given there was no lawyers in the family. But then I went on to law school and did fairly well and went to a big major law firm that existed at the time in Miami called Steele, Hector, and Davis. Obviously, I thought I'd be a tax lawyer because why not? I was an accountant undergraduate, so I'd be a tax lawyer, except the partners there persuaded me that I seemed to have the gift of gab and that I should really think about being a litigator, which, by the way, is lesson number one. Listen to the people around you, listen to people who might steer you in a different way than you yourself thought you might go. And so I said, well, fine, I'll try this whole litigation. And I got the bug early on. And when I got the bug in the late 80s, early 90s, there was no such thing as international arbitration in Miami for sure. And in most of US, it was not. I mean, I think Yasmin knows Europe had caught on to that much earlier in time. ICC was long since had been established. But in the US, it wasn't quite as normal. And if you really wanted to be a trial lawyer, you went to court. And so for the first 10 years of my career, I hung my hat with a partner from Kirkland & Ellis, and we tried cases around the country, national cases, and I loved it. And I loved being in the courtroom, and I loved the whole experience of going to trial. Except I quickly found out that under U.S. trial systems, about 97% of them settle before they actually go to trial, which to me was kind of like preparing for the Super Bowl every year and then never getting to go to the Super Bowl. Which is kind of like my Miami Dolphins feel to me where I live. But so right about then, and this now we're talking about the late 90s, early 2000s, this whole thing about international arbitration really started taking hold in the U.S. with, as Jasmine mentioned, Latin America being in our backyard, lots of development, a lot of infrastructure, and those deals really being more prone to being in an international arbitration fora rather than being in some local court or even courts in the U.S. And I quickly found out what I really loved most about it was that less than 50% of those cases settle, and they actually go to final hearing, which is the best and the most fun. So I do get go to a lot of Super Bowls. And nowadays, just to give you an idea, just out of our Miami office, we try roughly every year 9 to 10 major hearings, which means that everyone in my team is either preparing for a hearing or in hearings every month of the year. And so that is an amazing, great environment that we love to be in. But like I tell the young people, if you don't like that, if you don't like that kind of pressure of being in a hearing and a trial, don't sign up for this plan because that's what we love to do. I think one last thing I'll say that we haven't really touched on, but given it's the ILS, and we should, is it's the cultural aspect. I think what's most fascinating about what we have been blessed to do as a result of dumb luck is meet a lot of interesting people, lawyers around the world, different ways of thinking about things, but ultimately getting to the same conclusions. And I think that's what makes international law and international disputes most interesting to me.
Chris.
Yeah. So my story begins in this regard actually at the SEC championships for track and field a couple of decades ago. Um, as a result, I had not qualified for the NCAA championships. And so I had suddenly had a bunch of time for my summer free. Well, as it had turned out, as you do, I was a Chinese minor in undergrad. And so I'd been given a grant by an organization that no longer exists called the Confucius Institute, which was giving generous grants to American students that wanted to study in China or that were studying Chinese language to go spend the summer in China. So because I suddenly had a summer free, I went to Beijing and was there for several months at Beijing Language and Culture University. And it was my first time going from the busy metropolis of Irmo, South Carolina to Beijing, in a neighborhood that had more people than in my entire state. And from that moment forward, I was hooked. I was already in business school. I knew that I wanted to do some combination of business and law. That was just my interest. And so when I eventually went on to the University of South Carolina School of Law, I was looking for ways to continue to build on that. And the way that I did that was South Carolina still has this program. It's a cooperation agreement with the Gray's Inn of Court in London. And so I did a Maymester in London for about 6 weeks where I get introduced to this mystical art of international arbitration. Um, and again, this is sort of feeding my now interest and obsession. And so there's an LLM program for international dispute resolution in Chinese law at Tsinghua University. So I moved, in fact, and did my 3L year at Tsinghua. And I was able to get my JD and LLM at the same time. I stayed in Beijing for some time after that, working for a couple of different Chinese law firms before eventually returning to the United States. Did a judicial clerkship, then worked for a civil litigation firm for some time, doing eminent domain work, taking property from behalf of the state, being a local villain in that regard, but eventually also working for the Charleston Port Authority as one of our major clients. And during that time, and it's something I think we'll come back to here in a few moments, I spent a lot of my time during that period writing and being as active and including ABA events with international law, writing about international arbitration and doing that kind of work. And eventually that led to an opportunity with a little company called GE, more specifically Baker GE. And because of an article that I'd written while I was doing my civil litigation practice, the then head of litigation called me up and said, "Hey, I really like your article. Would you consider coming to work for me in Florence?" And I said, like, there's a Florence, South Carolina. Y'all talking about Florence? Or did you mean Florence, Italy? And I took them up on that answer. And so that was 7, almost 8 years ago. I've gone from sort of an entry level role there to now being the global head of litigation, the global litigation counsel for oil field services and equipment, which means we resolve disputes all over the globe. But similar to what Eric has talked about, even when I was in college, I did my senior paper on Chinese investment in Africa, which was the ultimately to set the groundwork for Yilu, which is the Belt and Road Initiative, One Belt, One Road, which Xi Jinping came up with that in 2014, but they've been setting the groundwork for that years earlier. So I think the common thread that you're hearing in all of our stories is that it's an interest in international law and it kind of continues to build on itself. And even if you don't have a job that directly puts you there, it's continuing to feed that interest over time, that will allow you to open up your opportunities. And I guess the last point I would say as we pass to the next question is a lot of things you'll hear from me today are from a business standpoint because that's kind of been the hallmark of my legal career.
Thank you so much. There are a lot of commonalities, and I could kind of muse about them, but I'm going to shut up and we're going to keep going. Thank you.
Yeah, maybe Chris, we could follow up with you a little bit. Interesting to hear that by college you were already studying Chinese and taking advantage of an opportunity to go abroad. Did you have an aspiration to live and work abroad semi-permanently before you aspired to international law, or how did that relate?
Yeah, absolutely. I think, all the experiences that I've just told you about fed those things, but I think the groundwork was set in the fact that although, as I've mentioned a couple of times, I'm from South Carolina, my parents are New Yorkers, proud New Yorkers. They've been out in New York 30 years and they'll still tell you they're New Yorkers. And they had left home when they were quite young. My dad, ironically enough, also on a track scholarship. Um, and their willingness to go to some place that is so fundamentally different than New York and explore the world, let me know at a young age that, yeah, that's something that's possible. And I think if you have an interest in this kind of work and in this kind of lifestyle, the more you're exposed to it, the more that you feed that interest, the more opportunities come. And when the opportunities come, you eventually say yes to one.
It's great. You've had the benefit of being both in-house and in private practice. How would you contrast the two experiences?
So I think it's a little bit to what I've just alluded to a moment ago. When you're in private practice, and Dan might agree with this, you're really focusing on what is the legal advice and making sure that you provide quality legal advice to your client. When you go inside as an in-house counsel, sure, you're still very interested in making sure you give sound legal advice, but now that all of a sudden becomes a little bit of what Eric does in terms of policy making and making sure that your legal advice adheres to the company's strategy. That you might have the right legal answer. What is the ramification of that? You've got the right legal answer for the United States. It turns out you can't do that in Korea. Turns out you can't do that in China. What are the implications of that? And making, we'll talk, we won't get into the, the merits of it, but we'll say, when there are sanctions put on a country and that is one of your largest markets, how do you deal with how the shareholders fall out from that? How do you deal with the contracts that you have to break and the litigations that might come from that? So you spend less time than Dan and his colleagues might, or Tack and his colleagues might, appearing in front of tribunals and courtrooms at some point, because instead of doing that, you're trusting your external counsel to do that, and you're having to make the strategic decisions to run the business.
That makes perfect sense. One final follow-up. Do you have any suggestions for lawyers who are looking either to start out in or to transition into an international in-house position?
Yeah, I'll refer to my earlier point to bring it home one more time. I think you need to start thinking about yourselves as products, and those are things that when you hear my comments, you'll hear me talk about that a lot. Is that a lot of times law students will say, well, I need a bunch of credentials because we like to be good rule followers sometimes in that way, and so I'm going to go get an LLM and a doctorate in law and do all these things, and maybe that's the answer. But the question is, in the industry in which you want to work, what is valuable? What's the demand? Where's it going? Can you build your career in such a way or add to your skill set that's going to immediately impact that or add something to the conversation? And one of the ways that I did that was now almost about 8 years ago, I started a podcast. Everyone's got a podcast, but I started a podcast called Tales of the Tribunal, where we interview people from around the world of international law, business, and dispute resolution, available on the Apple Store, Spotify, wherever you get your podcast. But that was a great marketing tool for me, and it's become quite reasonably well known in the international arbitration and legal space to some extent. And so ultimately, yes, that provided value to the audience, but it was also about getting my name out there. And I think about don't necessarily start a podcast, but what can you do um, in order to bolster your credentials or your reputation, not necessarily your credentials and your skills, what skills that you have that you can offer the market.
Thank you. Carole?
Yeah, Yasmin, I wonder if you could say a little bit more about the transition to working in the United States and when and why did you decide that and how did you make that happen?
It's kind of difficult to replicate. I had gone to study for a year in Texas after finishing law school in France, and I returned and I joined the firm at my first firm, as I told you about. And I had not taken the New York bar exam after finishing my year in Texas because I really didn't think I wanted to work in the U.S. And that is because I think that was still the beginning of the time when you thought about emigrating for work. It was not the trend has not picked up yet. You worked in international arbitration, and to the extent that you did that to study or possibly to another European country, but that was not necessarily in the realm of possibility that you would emigrate for work. And I immigrated because my boss told me when I'm in Paris, you should take the bar exam. It's good for you. It's good for the firm. I took 2 months off. I went to the Barbary and bar exam, and there I met someone who became my husband and who lived in New York. So that's the reason why I moved to the United States. This is as I was saying, this is a little hard to replicate. It's been an interesting process because then I started interviewing with firms, and I realized that when you move to New York, you have to specialize. You cannot really just come from a small firm and say I can do anything. And thank God, and thanks to having worked with Alexis Moore, he had already good reputation. So I started talking to firms who had an international arbitration group, and that's really what I joined. I sort of went with the flow, and I interviewed with someone who became my boss was David Lindsay. My friend is called James Lindsay, and David Lindsay was with Dan Gonzalez, started his career with Dan Gonzalez at the same firm in Miami, and sort of adopting a little bit what Dan was saying earlier about how he got into international arbitration. Dan and David's generation are those who really started the international arbitration the way we knew it. They are litigators, but they had the humility and the intelligence to try to understand what international arbitration was and how different it was from what they had learned in school. And this generation is has been very interesting because there's several of them, all the Armas, etc. They were interested in the diversity and in women and in people who were not necessarily trained in the US. And they were among the first ones to start telling their partners in the litigation department that you didn't necessarily have to have a JD to be an effective advocate. And foreign lawyers had something to bring to the table. And I really have to give huge credit to that generation of lawyers for giving several of us the chance.
So bringing that up to date today, when the environment is quite different, at least in the United States, do you have advice for students who don't have a JD, got their first degree overseas, maybe have an LLM, but they're interested in building practice here?
Yeah. Well, I think at least they don't have sort of the admissibility problem. Firms, big difference from when I started my career in New York is that there are now international arbitration groups in law firms. There were no international arbitration groups at the time. It was litigation and dispute resolution. And within that, there were arbitration practitioners. That has completely changed. And those groups have developed also by hiring LLM students, acknowledging that this was a necessary means of not only diversifying their practice and gaining credibility with their clients, but also building a network of colleagues abroad who will work with in the future, who will send them cases, et cetera, et cetera. So, and so how to maximize your chances of getting an LLM? There's nothing really I will say that you didn't know. Academic excellence is really what firms look at. And it's not necessarily what you've done during your LLM. If you have picked LLM, I do not necessarily recommend that you pick sort of the international topic subjects unless they're really highly technical. I think what litigators or heads of the international arbitration groups look for is a very good thinker and technician and writer who has decided to grapple with the basic run-of-the-mill topics of contract, civil procedure, etc. This is, I think we've been overselling a little bit the LLM on international arbitration, international law to foreign students. It's been a very profitable process for many firms, but I have been telling a lot of professors at Columbia and NYU, you have to stop selling the dream a little bit. So this is something else, I think. And also be mindful that you are, as I said, coming as a builder of networks, of connections, and so realize that you have to come from a country that you have to speak a language where the firm you're contacting does practice. And if you're in New York, you're talking about Spanish and Portuguese primarily. And also to what extent you can you sell yourself as a potential bridge between the people you're looking to work with and the people in the country of origin. And in between, it's really bolstering having an exemplary academic record and having been lucky to be at the right firms in your country of origin.
Thank you so much.
Maybe we can pivot to Eric next. Eric, you've talked a little bit about the evolution of your career and how you ended up with the government. But maybe you could tell us a little bit how you would contrast working for the government with being in private practice, apart from the fact that you're doing all these fabulous things with Ukraine and other jurisdictions.
Sure. Yeah. And I thanks so much for switching to me. I'll just note I have to hop off in about 10 minutes actually to go and meet our State Department colleagues. So I'll answer this question, then also give a closing thought about if you are interested in a career in government international law lawyering. So differentiating it from private practice is, to me, fairly easy. In private practice, you have a specific case that you are trying to win, and the terms of success are quite finite. You get an award that is favorable to your client, the damages sum is satisfactory, or the claim is dismissed entirely. The client is happy. In government lawyering, you really are designing a theory of change, and you are responsible for both assessing things as they are now, but also as they might be in the future, as they might change, and how that change will actually take place. So that requires some additional calculations, maybe the most important actually being a political calculation, as well as a legal calculation, and acting as that bridge between what is technically possible under the law, so engineering solutions under the current terms, but then also identifying what small changes you might actually put into effect to affect large change. That's the key difference, right? The transition, I will say this job is very travel heavy, and in that sense there is a similar number of hours as in working in private practice. It's just a very different kind of taxing. We've been in country in Ukraine about 4 times since 2023. No intention of stopping, but that obviously comes with a certain degree of some precautions that you have to take, and it also just takes quite a long time to get there. That's Ukraine, obviously. I've also worked in Central Asia and in Africa, and they all have their own sort of unique contexts and peculiarities. So flexibility and approach, I think that's a commonality between large firm practice, sort of adapting to the facts of the case as you receive them. But I guess I'll maybe steal a phrase from a diplomat that I like, John Sullivan, former ambassador to Russia. Diplomacy is really the art of the possible, and I really think that this kind of lawyering is, in that sense, the art of the possible, navigating a very complex bureaucracy to ultimately get to yes, which, obviously is meant to advance U.S. interests and the interests of American investors. And if you would like to learn more specifically about our alternative dispute resolution reform work, we are actually being hosted at the Southern District of New York next Friday for a lunch and learn. I'll be there with another attorney on my team, and I'll just drop the registration link in the chat. And as I mentioned before, if you're interested in a government lawyering career, even if it's not at the Department of Commerce, we know a lot of people, and I'm happy to connect. So I'll just give you our general email as well as my own before I hop off.
That's wonderful, Eric. And any quick suggestions for lawyers who want to get into government practice?
So the government is so diverse. There is some legal office that is doing what you do right now. I guarantee it. I saw someone in the chat mention that they're doing employment law. That's ubiquitous. That's all over the place. There's if you're an arbitration lawyer, there are arbitration offices in the most peculiar places, one might say. The federal government actually had its own in-house sort of arbitrator and mediation conciliator service that wasn't on my radar until I just happened upon it while we were looking for the right sort of USG experts to plug into our work in that case in Pakistan. But yeah, the government is a very diverse fraternity. It's in some sense like a university campus. There is someone doing what you're doing, and it's just sort of about making that connection. And I will admittedly say are sometimes not the most well publicized sort of opportunities. So networking goes a long way.
Thank you.
Eric, can non-U.S. citizens work in your world?
Wow, that's a great question. So for our office specifically, no, there is a national security component. And in many lawyers' offices, you'll have to pass sort of a background check and a security clearance process, and U.S. citizenship is required. So that's like obviously for full-time employment. What the U.S. government does have sort of the capacity to do is in some ways, is in some contexts, to take on subject matter experts that need not be U.S. citizens. So this is particularly useful if you have a specific geographical expertise. I'm looking for an ADR expert in Turkmenistan. Like that is so specific, there is likely not going to be a U.S. citizen that satisfies that. And so you can privately contract with that sort of person to ultimately for whatever you actually need them for. But I'll pause there. But that's a great question. Thanks, Carole.
Thank you so much. So Dan, we have a bunch of questions for you, and they go into 2 groups. One is about your career and how your practice has changed over time. And the other is comprised of questions about hiring policies for differences, different backgrounds, different credentials, and just drawing on your experience in the firm. So I'm going to start with your own career. And we're interested in how your practice has evolved over time and whether it's gotten more or less international and sort of how you've had agency in shaping that or not.
Well, I guess I'll start by picking up on something Chris said, comparing in-house versus outside counsel role or focus or emphasis. I think that for outside counsel, that has changed also greatly over the years because at one point, earlier in my career, clients would come in, they would have a betcha company case, and whether I was already the senior partner on the case or even before that, to some degree, it was fungible, right? The issues at hand, the legal issues is what we were dealing with, the client, and you just looked at whether it was a contract dispute and what was it about, what was that contract, how do you deal with it, and what court were we in, and how are you going to deal with it? I think to challenge a little bit Chris's point, we as outside counsel now, our clients are expecting us to be much more knowledgeable, not only about their particular industry, and it's very unlikely that I'm going to get retained by a client today if I can't demonstrate that I know their industry. Step one, that's just to get me in the door. And secondarily, I really need to know that client, and more times than not, and certainly if I'm going to keep that client long term, I have to know all of those same sort of politics and nuances, what matters to that client, what's happening in that boardroom of that client, what do they care about? And again, the nature of the cases that we typically get, and I'm lead counsel on, they are betcha company cases, so they usually are already at the corporate suite level when I get there, but the client is going to immediately expect me to really know their industry and know them well. And now that doesn't mean I don't go after new clients. It means that the days when we used to do pitches where you would just talk about all the great thing the firm does and all our great pro bono and, beautiful glossy brochures that our marketing group puts together, my perspective is clients don't care or want that anymore. That's a given. The given is that you're operating at that level. They want to know, even from the pitch point, they're going to want to know what's your strategy for this matter? What do you know about this industry sector? Who do you know in this industry sector? And what's your plan? And what's your plan without being able to bill a single dollar yet? It's just, what's your plan now? And tell me how you're going to attack my case. So, and I think that's what wins the case. So I think that's a very big change in that the notion of being, and long since I started my career, the idea of being a generalist in dispute resolution and litigation or arbitration was already disappearing. And you had to become more of a specialist. But at first, it was just a specialist, as Yasmin described, between going into arbitration like David Lindsay and I did versus going to just litigation. But now it's really having to be an expert and really knowledgeable about your particular industry sectors that your client's operating on. So that's sort of the fundamental big change, I think, that we've seen over the years from my vantage point. In terms of advice to young people, which I think is the most interesting part of this panel to talk to, is that's also changed greatly. Harping back to something Yasmin said, when I started this area, the challenge was that nobody was doing it, and we were just sort of building it from whole cloth. And by the way, while we were building it, we were getting a lot of criticisms because my colleagues around me who were trial lawyers were saying, well, you're going to go off to do that arbitration stuff? Well, that's not real trials. And then, of course, I had to explain to them over time that, well, a monkey can cross-examine a witness if you have a 3-day deposition transcript of them. Go try to do that in international arbitration where all you have is a 5-page witness statement that was prepared by the lawyers and documents and nothing else. And you then tell me what's more challenging. So over time, a lot of those lawyers came to realize that arbitration was much more exciting and challenging than that one case they got to do every 5 years. And don't get me started on my Queen's Counsel and King's Counsels and their views about doing these cases in the UK that we do and enjoy doing against that bunch of advocate lawyers. So that's changed greatly. But my advice, if you're a young person and you want to get into this now, which is much more saturated, Now every university, as Yasmin says, I teach a class tonight. In fact, I teach a class on advocacy and international disputes at the University of Miami at the LLM program. So I'm very familiar with what Yasmin is saying about how the universities have done great pushing this aspect. Today, the market's so saturated that what you have to do is create your unique self. You have to demonstrate. It's a given. If you're going to cut, before you ever get to my office to do an interview, you already went to the top law schools. You already graduated the top of your class. You already did all those things. None of that's going to impress us. What's going to impress me, by the way, is something Chris said. If you got a podcast that you just sort of did on your free time and you got a real following in that, I'm interested in that. That's going to perk my interest. If you did military duty somewhere, whatever part of the world, that's going to interest me. Anything that sets you apart and demonstrates that you're both committed to this practice, but that you got something that's going to be really interesting, that's going to really make you a full character person, is A, going to make me remember you more, and B, is going to make me probably much more interested in your ability to multitask and to really develop, because one thing you can be assured about in this practice is it's not going to stand still. So the more skill sets you bring to the game from day one, the more interesting you're going to be in terms of how you're going to develop into the future.
Having said all that, which is really interesting and helpful, think about sort of categories of students and young lawyers based on their degree, somebody who doesn't have a JD, somebody who does, based on sort of elite schools that your firm might be have a list of go-to schools, and what about students from other schools? Are there opportunities for students in kind of the other categories?
Yeah, so let me unwrap a couple of those questions. So JD, non-JD, LLM. Well, I happen to sit in a state, the state of Florida. Texas is also another state. There's a number of other states where if I'm going to hold you out as a lawyer, you have to have a JD. So you can't just operate. You can't hold yourself out as a lawyer with just an LLM. That doesn't mean we don't hire LLMs. I have several LLMs right down the hallway here, but they of course have to be held out as something other than a lawyer. And to some degree, if somebody wants to do that for a couple of years at a law firm like mine, definitely we have a space for that, and we have a category for that. But I often will have a chat with a young person and say, well, what's your long-term plan? What do you see yourself 5 years from now? Do you really want to develop and evolve in this area? And if you do, and if you want to do it like a place like Florida, then the JD number one's a must. But beyond being a must, it goes back to my earlier point. If you're a lawyer who is both an LLM because you came from a civil law background, for example, and you have good knowledge of civil law, and now you couple that with a JD degree under common law, now you've made yourself at least a little bit more interesting. Not that there's not a bunch of those kind of folks, but now you're starting to distinguish yourself, and you're growing your profile in a way that can add. And nowadays, most of the universities will let you do that with about another 1.5 years added time to your LLM. So it's something you should consider. It doesn't mean you have to, but it's something you should consider depending what you think your long-term plan is. And I do, to Yasmin's earlier point, I worry at times whether the academics don't focus students enough on what is your life, what is your career going to look like 5 years down the road if you do or don't do these things. So that's step one. So definitely we have room for both, but you're going to have a much longer running path if you've got the dual degree, or you've got a JD in the US for sure. In terms of what law schools we look at, obviously a firm like ours is spoiled in the sense that we can go to the top law schools in the country and in the world to recruit. But honestly, that's not, to me, the sell-all. I look for hunger. I look for somebody who just really wants a job. And I have hired some of my top associates, senior associates now today. I'll tell you a very, very quick story because I know we're running out of time. But my top senior associate today went to a law school, will remain nameless, but was not one that would ever be on our list. She came in as a contract lawyer for an outside contracting firm for a very major $1 billion case we had for a major client. She shined to the point where all my associates were saying, well, you need to check with so-and-so because she's the one that knows all the documents. I finally had to meet her. When I met her, she told me she wanted a job, and I said, "Well, I can't hire you because I have a non-compete with a contracting firm, and for 2 years. And on 2 years and one day, she came back and says, "It's the non-compete is over. I want the job." And she got hired, and she got hired as an inside contract lawyer, and then she shined at that. And then we moved her up, and I pushed to advance her as a regular associate lawyer. And today she's a senior associate on partnership track. So my point is, there is no one track. It's show me the hunger, show me the desire, and you're going to get the job, and you're going to succeed at the job.
Yeah, and if I can echo something Dan said really quickly, and I'll make it very fast. You know, um, it's not about having the top grades. It's not about going to whatever brand school, doing any of those things. It really is demonstrating that genuine desire that, as you can imagine, everyone sort of sees the idea of living this international lifestyle, traveling, flying, doing all these stuff. Sure, that's cool, but it took a lot of time and work and effort to get there, and there are probably easier ways to get there if you just want to go fly around. You know, are you active in the community? What have you published? What have you put out there? Or do you go to events? Any of those types of things? And I put a few suggestions in the chat. Those are going to take you as far, if not farther than, as Dan said, the assumption is everyone is qualified, everyone's good, or you wouldn't be trying in the first place. But if, for example, you didn't go to brand name school and you don't have the branding and all that stuff, figure it out, make your own.
So I know we're running out of time, so I just want to add one thing. I totally agree with everything you all said. And in fact, one of the things I wanted to mention today was I find people with enthusiasm, right? Enthusiasm is what matters. You can't teach someone to have enthusiasm, but you can teach almost everything else. One other thing I wanted to mention, which is I think is slightly different than what other panelists were talking about, is an instance where you enter a practice where you're not doing exactly what you want to be doing, which is international, which is what happened to me. I was doing a lot of domestic work at the outset, as a litigator, and I ended up kind of making my own path into finding the right partners, the right client contacts to work on the matters that I wanted to work on that were more international. And one thing I wanted to just really emphasize is an advice that I kept getting from everyone who were trying to help me with this is be an excellent lawyer first. If you're not an excellent lawyer, no one cares about your language skills. And so having too many or your world ambitions, having too many I have a lot of people ask me about how to get into one area of law or do more of this matter or that matter, and the advice I always give is just learn the basics and do an excellent job. And then once the firm or the organization understands that you have qualities that are exceptional, then you can push what you want. And it magically becomes easier when people appreciate the work that you already do. So that's something that I really wanted to emphasize for students who are starting out and who may not get their first job in the international space.
Carole, if I may, we have been talking a lot with people who have worked in the US. There is room to grow outside the US and do genuine international arbitration. And in those markets, the firms may be much more accessible because US firms have a way of attracting the best and the brightest from everywhere. And it makes it very competitive. And it's all the more competitive that these firms service high-level clients, very high fees, and so there's a very difficulty in entering those organizations. But outside the U.S., there's a lot of very established markets, more than New York or Miami, Paris, London, Singapore, and there's a lot of emerging arbitration.
This is crazy.
To bear in mind.
This is next level, Rain. Is it really? Oh, I feel so bad. I'm crossing the road.
Hey,
I do?
We'll try to fix that. Hold on.
You should hide under there until the bus comes and you book it over
Brandon.
there. You want to do that?
Brandon.
Hey, you off mute, man.
Oh, sorry, guys.
Get safe across the road, though.
Thank you. Sorry, it's raining like crazy. Sorry, guys.
Carole, do you have one last question for everybody before we see if there are questions from our participants?
Or maybe we should open it up. What do you think, Bryan?
Sure.
So does anyone have, first of all, Tak, thank you for jumping in with that. We were going to get to you, don't worry. But you did kind of save us from going through the questions we had. So that was really helpful. Thank you.
We have a question from Erica Level.
Thank you so much for your time today. Coming from a great perspective on the dispute and the arbitration side, do you have any recommendations on how to get involved now as for the commercial transaction side or places to learn more about this environment?
Well, you are in one of the best places you can be in the international law section of the ABA. That is an untapped superpower. And I tell law students this, and it goes one ear and out the other. So, just in case, and you may not know, and certainly didn't know when I was a student. So the ABA is structured across sections, and within those sections there are committees. And in every section probably has a committee that is designed specifically to the thing you're interested in. And for sure, what you've just said is commercial transactions. There's definitely committees that will align to that. I think the first thing that you do is you have the right to join as a student member any section for free. I think that's still the policy. It was at least a couple years ago. And if that's the case, go look at the committees, go join one, attend a few meetings, and see if that's what you're interested in. If it is, they'll put on events, help with those events, and just sort of by osmosis, you will get more and more involved. In addition to the things I've said in the chat, although I was talking about disputes, it also applies to generally any field that you want to get in.
Thank you so
Those
much.
committees, by the way, Chris is completely right. And those committees, I chair one of the other committees, and they love volunteers. And so I know you probably are stressed for time and all the other things, but it goes a long way to raise your profile. If you can volunteer for these, you're typically going to be rubbing elbows with a lot of very senior folks and getting noticed very quickly because we're always looking for folks to help out on various tasks that the ABA has. Because it's at the end of the day, the whole organization is a volunteer organization. So volunteering to take part in interesting projects is a great way to get involved.
Yeah, Dan, I'll add a coda on that very briefly about a little more. When I was first starting my career, the ABA was putting on a boot camp series on international law and a whole bunch of different topics there. And sure, everyone took the ones they were interested in. And, there was like, I think 3 or 4 topics that no one wanted to do because it just was going to take time. And I said, I'll do it. And so I went and I got to present those PowerPoints. And still to this day, well, until they updated to the next version of that, it was Chris Campbell, international M&A, international disputes, and all these things that were done. Well, hey, man, if you were the person there to do the work, it falls in your lap.
Yep, you get the credit.
That's great. We have another hand up, and I'm sorry, I don't want to mispronounce your name. Ms. Obo?
Oh, that was definitely a great try. And you got and
I get an A
and
for
you got
effort?
it right.
Hey, for
No, not just E for effort. You got an A because you got the last name right. So that's good.
Thank you.
Good evening or good afternoon, everyone. My name is Eddie DeYoung Obote, and my question to you all is, what has been your experience working with non-lawyers or attorneys? I'm a student. I'm not a law student, but I'm studying doctorate in law and policy, and I have a focus in international law. And so I'm looking more so at both law and policy functions and things of that sort. So I'm just curious of how your experience has been with those who are not necessarily barred or are attorneys or lawyers in the international law space. And to your point, Christopher, I do plan to become a student member and get involved in the international law section and the Africa one specifically. So I've been doing some research and I plan to volunteer, as Dan said, in those areas. So I just wanted to know what your experiences have been so far.
So many opportunities in Africa. I don't want to start because I've started on other questions. If someone else wants to take it first, otherwise I'll jump in.
Thank you. Yeah.
Yeah, so there are definitely opportunities. I think it's, not everyone that even has a JD and goes and becomes a lawyer wants to be wants to give legal advice or appear in court. So I think whether it be the opportunities Eric was talking about in terms of policy making or advising organizations could be one route, whether that be the NGO space, whether that be something that might even be outside of the United States. There are a lot of organizations that might need that skill set. If that's your route, like Dan talked about, like Yasmin talked about, like Tack touched on a little bit, I think what you'll need to do is to then sort of just be very clear about what skill sets you're bringing to the table for the roles that you're applying for. So there'll be, non-lawyer rules. So then, okay, do you speak a language? Do you have specific cultural experience? Do you have a worldview that is helpful? I think then making it very clear and then marketing yourself in that way, so that it's clear what you're trying to do, will help you out in that regard.
Anyone else?
Carole, if I may, thank you so much for offering for us to reach out to you and Ryan if we're interested in volunteering with this committee. Would you mind just sharing your contact information or the best way for us to reach out to both of you? And thank you for your time today.
Absolutely. I'm putting it in the chat. And Ryan,
I've done mine as well. We have another hand. Is Dylan? Is it Capuccio?
Capuccio. Very good. Can you hear me?
Yeah.
Thank you. Hi. All right. Thank you guys all for hosting this panel today. My name is Dylan Capuccio. I am a 3L at the Charleston School of Law with a strong interest in international law. I actually had the pleasure of talking with Chris recently for International Law Society. So my question to you guys today is, what separates a good law student from one you would actually want to hire, and what kind of qualities you look for in associates or junior associates? Thank you.
I mean, I guess I'll lead off just because I've already sort of given you part of that answer, which is you're looking for uniqueness. I mean, I think you also heard from others talk. Quality is king. Okay, there is no replacement for working hard and doing well in law school. That has to be almost a threshold given, and then from there, it's everything else you do to enhance yourself. And by the way, that's not just about getting in the door to get the job. I think I often have seen, not often, but at times you'll see new associates come in and they're not sure. They worked really hard at law school, they did great, they get the job, and now you're at this big major law firm, and it's like, well, what do I do? I got to start all over again. And how do I now, continue this career? And I often tell them that your number one job at that point, once you have that job, is to be the best possible lawyer you can be. And that means don't get distracted by all the other things. So there's a lot of other things that you need to do and should do, such as being involved in the ABA, being involved in other organizations, getting out there and raising your profile, social media, all of that. All of that's important, but all of that is secondary if you don't develop the best quality skills. Because what you're going to find if you become a really, really honed in good lawyer and the lawyer skills are there, everything else, even if it changes around, even if the world will change again, which I assure you, if you're a young lawyer, the world will change at least another 4 or 5 times while you're practicing law. But if you develop those skills early, you'll be able to transition those skills to no matter how things change and no matter what everybody says, how AI is going to replace all of us, somehow the really great lawyers, really well-skilled lawyers will figure out how to work even within that environment of the AI next to you. But that, I think, is the number one. And that's actually what we look for when we're looking to hire is that somebody who either they already have the skill set or they demonstrate because of their quality of what they do, that they're going to have that skill set to carry forward no matter how things change as we move on.
Thank you very much.
Well, I think we're a little bit over time, and I know for some of our participants it's kind of late, including Chris. But I want to thank all of our panelists, including those who had to jump off a little bit before now. We really appreciate your input and your comments. I think you can tell from the folks attending the session how valuable that was. And thanks to all of the rest of you for attending and for joining us. We look forward to people reaching out to see how they can get involved, and whether it's with our committee, the International Legal Education and Specialist Certification Committee, or other ABA committees. There's something for everyone, as Chris said. And barring any last minute comments from Carole or our speakers, thank you all.
Thanks, everybody.
Have a good one, everyone.
Take care.
Thank you.